selection and appointment are slightly different. See exactly what is happening in your mind. No, it is a writ.
To whom?
In general, just
to
like,
whom?
just behave it.
Correct. Mr. Bhushan, your Snoopy invasion, you are expecting that there will be only pure thoughts in the minds of the people.
No, I'm not expecting that. In order to avoid arbitrary appointments or arbitrary selections, it is better to have a slightly larger body. For example, 3 is better than 1, 5 is even better than 3. So of course, it should not be so unwieldy that it becomes impossible to convene their meetings and get them to function, etc. But
3 being the ideal.
5 in my view.
No, 3 being the ideal number has already been pronounced upon in TN Sessions case. In TN Sessions case, you will see the discussion there. When the government changed it by the ordinance in 1993. Initially, it was only
3
one
numbers of election commissioner.
election commission. If you make it a very unwieldy group, you will have possibilities of independence being compromised because of that. So the lesser number of people available for the powers that be.
So sure about that. I feel, my lord, of course it should not be unwieldy.
It should not be unwieldy.
Should not be unwieldy. I agree with that. But one person, my lord, if you leave the discretion to one person,
that's what happened with
there is a much larger scope of arbitrariness.
That's exactly what has happened with Session. Some of the remarks made against Session in the Sessions case by the court, which led the government to actually constitute the commissioner, the election commissioner.
No, he was independent, but he was also very dictatorial.
Exactly.
He was.
There are so many aspects to be balanced.
Yes, your lordship is right. What I was saying was that in the selection committee, actually this question arose when we were discussing the draft of the Lokpal bill, etc. Who will be selecting the Lokpal? And therefore, I had always felt that the selection committee should be a sort of broad selection committee of maybe 7 people who should select the Lokpal. But, so therefore, the government may have 1 person there, the opposition may have 1 person there, but then 5 independent bodies should also be there, so that the dominant people who select are independent, not really the stakeholders, so to say. So, in my respectful submission, my lord, the ideal number of the selection committee for the election commission should be 5. It's not too unwieldy, and it will ensure that the arbitrariness is reduced substantially. So 5 could be 5 members of the collegium, 5 could be 3 members of the collegium plus, let's say, the outgoing election commission plus the Human Rights Commission.
You have made that point. We have understood your point.
Yes. So
now, what more is it that you want to say?
So then, my lord,
you're relying on all the reports.
Now I want to read some very important observations in these judgments.
Yeah. So you have not yet taken us through the text of Article 324, which we will request you to do.
Yes.
Only then we will have a.
Yes.
What are we doing actually?
Yes, my lord.
Because there's no challenge to the constitutional provision of being a basic structure or anything of the kind. We have to take the constitution as it is, obviously.
Yes.
So we take Article 324 as it is.
Yes, my lord.
And try to do what we can.
Yes.
So let us say 324 in its
superintendence, direction and control of the preparation of electoral rolls for and the conduct of all elections to Parliament and the legislature of every state, and of elections to the offices of the President and Vice President held under this Constitution shall be vested in a commission referred to in this Constitution as the Election Commission. The Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix, and the appointment of the Chief Election Commissioner and other election commissioners shall, subject to the provisions of any law made in this behalf by Parliament, be made by the President.
So this is a key provision.
Yes, this is the
So
key.
your case is
Yes,
that as things stand, as it stood even at the beginning of the constitution,
yes,
the power to appoint lay with the president continues to lie with the president. Now, the president obviously means president acting on the advice of the council of ministers.
yes,
So therefore, the council of ministers at present decides to appoint, and this power is subject to any law made by parliament.
yes,
No law has been made. So there is a gray area, there is a gap.
yes.
So there you bring in Vinit,
Vinit Narayan,
Vinit-
Prakash Singh,
and then Vishaka also,
yes,
where you can perhaps, the court can fill in the gap
yes,
without doing violence to the terms of the constitution.
yes.
This is what your sum and substance of your cases. Whether we can evolve a system of appointment, having regard to the dire need for doing so, for the reasons which you have mentioned, till such time as the law is made, because we cannot possibly be ending up laying down. Even in Vishaga, the court said, lay down the guidelines till a law is made, and it took a good 2 decades thereafter, or perhaps even more, for Parliament to respond with actual lawmaking, which
course.
prevails today.
Of course, my lord,
That
if
is
you're,
a short area, that is an area where we can actually step in. This is what you're trying to say.
but the only thing is that,
We cannot say that Parliament is foreclosed from exercising its legislative powers based to entry 72 of list 1.
I agree,
Yes.
Of course, if this court says that we are giving this direction, that this selection shall be by this kind of an independent or a neutral committee. Selection and appointment are slightly different. Of course, appointment has to be made by the president.
That's right.
But selection can be made by a different committee. Then that law could also
That is a
provide.
gray area. That is the area
Yes,
where
that's the area.
we can perhaps step in.
Yes, yes, correct.
Till a law is made by Parliament. Because
Alright.
we cannot possibly stop or just stop the Parliament from making a law. As to whether that law can be challenged separately, that's a different matter.
Yes, yes. Same thing happened with NJAC.
Exactly.
NJAC.
We can't stop them from making a law, but then if they make a law,
We made a constitutional amendment,
that's right.
and that was also struck
Absolutely,
down.
absolutely.
Same thing happened in that
Now you can
UCL and ADR. Same thing.
perhaps read Article 324(5).
Yes,
Yes, we may not read the whole of it.
yes,
324(5) also.
yes, yes, yes. That's important.
Yeah.
Subject to the provisions of any law made by Parliament, the conditions of service and tenure of the election commissioners and the regional commissioners shall be such as the president may by rule determine.
So pause for a moment. That's a law was put in place in the year 1991, as you know. They made a law traceable to conditions of service and tenure, but relating to appointment per se,
They didn't make.
relating to Article 324(2). No law has been made by Parliament.
Yeah,
This
that's right.
is what is perhaps the position.
Yes, correct.
Then the important thing is
Proviso.
the provisos, the two provisos.
Provided that the chief election commissioner shall not be removed from his office except in such manner and on like grounds as a judge of the Supreme Court, and the conditions of service of the chief election commissioner shall not be varied to his disadvantage after his appointment. So this provides for that functional independence.
That's right.
So that the government doesn't have control over his conditions of service or his removal, etc.
That's right. There's an appointment and removal. The appointment is governed by 324(2). Removal is already provided for in 324. And there is no scope for the court to say something contrary to what is expressly provided in the Constitution.
Right. And
So
so
we are
far,
concerned essentially with how you go about appointing the chief election commissioner and also the election commission.
correct.
We take it that's your
That's the
only short point is about the appointment.
correct.
We can't be ruling on.
No, in my petition, but in one other petition, I believe the issue is also about the rules, etc. In my petition, both petitions, the only short issues regarding appointment.
So you've made these proposals, and then what is the state of the law in other countries? You have mentioned about South Africa, Ghana, in the US. You have given practices prevalent in these countries as well.
I have not really.
We have seen some of the other cases, like in the US, I think it has to be approved, president appoints, but it has to be cleared by the Senate.
Yes, yes,
Correct.
yes, yes.
Now you take a case where.
There are divergent models.
Huh?
There are divergent models across the.
There are different models.
That's it.
Not exactly.
So in any case, my lord, here I am going purely by the basic principle which your lordship has laid down. That is, in the NJSC case where your lordship said that look, judiciary has to be independent of the government because government is a major stakeholder.
That's right, absolutely.
Same principle I am applying here. Exactly the same principle. Election Commission has to be independent because government is a major stakeholder before the Election Commission. Just as rule of law and justice is a basic feature of the Constitution,
You have made that point.
democracy and free
No.
and fair elections.
Okay, then you could perhaps move on
Then
to the
the-
decisions you want to lay out.
Yes,
so
Lord.
that- and then we can
First,
go on to
the SCORA, which I have quoted the relevant paragraphs in this, at page 6 of the note, Lord, at the bottom, no one can deny, this is the quotation.
Mr. Bhushan, give the citation.
Yes, the citation, that is 1993, 4 SCC, page 441. And I am reading para 207, which I have quoted.
93.
93, 4 SCC, 441. In my note, my lord, everything is.
There's a compilation containing all the judgments.
Yes, no, this judgment is not in the compilation.
We have a compilation which is.
Acha, of the judgment.
Particular, the number of judgments which have been given, we don't know whether this is a part of it.
I'm not sure whether, this must be there.
Okay, then give us the citation.
1993,
Yeah.
4 SCC, 441. And I'm first reading, my lord, para 207.
But this is there in his note, which he has he's reproduced that.
That's good, that's good. So paragraph,
Paragraph 207.
you may just indicate a paragraph,
Yes, yes.
unless you want to read a particular portion, just give us a paragraph, we'll go through it.
Acha, all right. 20,
We'll spend the.
all right, all right. 207.
Yeah.
And here they say why the appointment is essential, why the appointment cannot be controlled by the government, or that the government can't be the prime mover so far as appointment of judges is concerned. Why independent appointment is necessary for securing an independent judiciary.
Yes.
They say that very clearly. So 209, they say the aforementioned discussion, I'll just read this one sentence, leads to an inescapable conclusion that all the factors mentioned above coalesce to support the view that the executive will not be justified in enjoying supremacy over the opinion of the CJI in the matter of selection of judges to the superior judiciary. So, and then, my lord, they para 321.
Paragraph 321.
334
Yeah.
and 334, one quotation which I'll just read, which is important. It is not the security of tenure provided to an individual judge which alone is the source of independence of judiciary. But there has to be an independent judiciary as an institution. The judiciary in India has to act as an impartial umpire to resolve disputes between governments and private individuals as well as between governments inter se. It also has to protect fundamental rights of individuals guaranteed by Part 3 of the Constitution. The courts in this country have already expanded the scope of judicial review by bringing in its ambit social, economic and political justice. Keeping in view the expanding horizon of judicial review, it is the paramount need of the time that not only the independence of the individual judge is to be secured, but the independence of judiciary as an institution also has to be achieved. The question that comes up, 335, then 335, the question which comes up for consideration is, can there be an independent judiciary when the power of appointment of judges vests in the executive? Same thing here with the Election Commission. To say yes would be illogical. The independence of the judiciary is inextricably linked and connected with the constitutional process of appointment of judges of the higher judiciary. Independence of judiciary is the basic feature of our constitution, and if it means what we have discussed above, then the framers of the constitution could never have intended to give this power to the executive. In fact, my lord, in the Constituent Assembly discussions also, the expectation of Dr. Ambedkar was that some law will be made to provide for some independent.
We are bearing that now.
Yeah.
Next judgment you are
In the form, the Union Executive has vital interests in various important matters which come up for
We
adjudication.
know that we have
Yes.
seen that. Yes. So that-
Then the next judgment is
Yeah.
Roger Matthew versus South Indian Bank,
Yeah,
2026 SCC, page 1,
yeah. Paragraph.
about the tribunals. Paragraph 153
Yeah.
says, Roger Matthew, 2020, volume 6, SCC, page 1.
Then
We are-
you take it that you will read each paragraph, each sentence of it, we will go through
All
it.
right,
But
all right, all right.
so that, you know,
So the basic point is the same thing they say about the tribunals,
that's right.
which they say about the judiciary. Then, my lord, in the second Scora case, that is the NJC case, 2016 5 SCC, page 1. Here, I have mentioned several paragraphs. I have reproduced several paragraphs which talk about the dangers of having this reciprocity. That is all right. You have the government also, you have the judiciary also in the selection of judges. Because there the law minister was there in the NJC Act as one of the people in the selection committee. And the secretariat was vested with the law ministry and so on. So they said this will lead to the danger of reciprocity, etc., which is also a big problem for the independence of the judiciary. That, all right, you appoint one of yours, we'll appoint one of ours, and so on. So, so that is why they struck down, look, government should have no role in this. And on that basis, they struck that down. So, para 310, 11, 12, 13, whole thing deals with the danger of
We'll
this.
deal with it. We'll deal. Next.
13, 14,
Yes.
15 to 16. We've given a long 17
Yes.
to 17, 19 till para 319. Then, my lord, so they deal with it in great detail, this problem with reciprocity and government having, that it will lead to this problem. And then, my lord, the next.
Bhushan, just would like to ask, just as an aside,
Yes,
I'd like to ask you one question.
yes,
Is there any system
yes.
devised by human beings which can be perfect?
No, no.
Cannot.
certainly not. No,
It cannot be.
Yes.
Because of our folly and our frailties
yes, of course,
and our character or the lack of it
no doubt.
more. That whatever system you may have,
Yes,
for example, even the collegiate system by which my learned brother pointed out,
has problems.
it has problem.
Yes,
So that's we have to. The most important thing is the pursuit of truth.
and to make the best
is more
possible,
important than pursuing what is the truth.
and to
So if
make
you
the
pursue
best.
truth to its end, we'll have problems. So
We'll not-
let us not take it beyond a certain limit, because there is, you know, we are imperfect. We continue to be imperfect, but we try to make the best of it. And that's what I think you are also trying.
Oh, Russell said something very interesting and important. He said,
In fact, if you have read Palkiwala's We the People, way back in 1989 when it was published, the whole book is based on the premise how we as a nation have lost character. And the whole, all this debate, all we are spending time over in pursuit of that little quality in at least some of our citizens.
so Russell
That is
said,
the tragic, state of affairs that we are reduced to.
so Russell said
All these discussions.
something,
People of character.
something important about character. He said, institutions mold character and character transforms institutions. So, in a science fiction novel long developed the technology of non-invasively seeing every neuron, every chemical reaction in anybody's brain. So today, I point my phone towards you and I can see exactly what is happening in your mind.
It's going to happen. What you
It will happen. It will happen.
It's likely
someday.
to happen.
Now the question is, what would happen? So some of our transparency activists who disagree with me,
Bhushan, one more thing, because to have a clarification. No, whether the petitioner seeks for a direction, we are not saying to the parliament, to come up with a law in terms of a 324(2), or this court to constitute a body in the indirect now for the purpose of the 324.
second, what your lordship just mentioned.
Make it clear.
Yes. I am not asking for a direction to parliament to make a law. Not
That is the prayer, that is why, time and again we put that.
That was the prayer in the unamended petition, which we amended subsequently. And that amended petition.
Second also, the amended petition also, you are seeking a writ.
Yes.
Seeking a writ means you cannot say that no, it is not to anybody.
No, it is a writ
To whom?
in general.
To whom?
Just like, my lord, the writ.
That is why we put this question, whether the first part or the second part.
So
Because we will have to be very clear on that.
it's
See, of course, 24(2), it casts an obligation. It is there. But at the same time, are you seeking a direction or a writ to come up with a law, or in the indirect now, this court to constitute a body?
I am not seeking a direction to come up with a law.
Make it clear.
I am seeking a direction from this court
That
to
is
the
right.
government
Only to make.
to constitute a selection committee in line with the directions of this court in order to secure the independence of the election commission, or in order to secure that the election commission is appointed independently and not appointed by the government alone. That's all.
Only to have a
Yes.
clarification.
I was at page 15 of my note. The second, or the next case that I have referred to is Prakash Singh.
Yeah,
That's regarding police reform.
that's right.
So,
That citation.
it's 2006,
Yeah.
8 SCC, page 1. Before that, Lord, I was, in the context of character, I was saying, suppose we develop that technology, which I was mentioning, what would it do to character? It's a very, very important question. If I could see, or if everybody could see what is going on in everybody else's mind, one of the consequences of that, of course, my privacy friends are aghast. Should there ever be some technology, there won't even be privacy of mind. What to say of any other privacy? But one good consequence would be that at least cheating would disappear in such a society. So character of people would get molded so that they don't even think of cheating, because they'll be caught out immediately when they think of cheating. So therefore, character is also a product of systems, etc. So if you make a transparent system, for example, then the chance of the person who is manning that system to act arbitrarily gets reduced to that extent. And that's why all these systems play an important role in determining how people will behave.
Correct. Mr. Bhushan, your Snoopy invasion, you are expecting that there will be only pure thoughts in the minds of the people.
No, I'm not expecting that.
No, I mean.
Not at all. In fact, my lord, this is one of the concerns which was raised.
No, I understand that, of course. Take it in that spirit only.
People might start thinking in code language.
Very interesting thing recently happened in US in some antitrust investigations. It was found that all these technology providers around the world, Google and so on and so forth, they were found to caught discussing one very important aspect, that how to economically grow And the one idea came to them is consume every human minute. So every human existing on this earth, bring them on a technology platform and monetize that time. So the technology maker who's going to bring this technology with the idea of bringing character in, so he's going to have a further idea, which is the basis of cheating and so on and so forth. And this has been actually caught, which was considered in the US Senate, Manasi, how the technology providers should be regulated. So they go down that route saying that every human minute should be consumed.